Good afternoon, Professor Barnard and Professor Piers. Thank you. Now, thank you for coming along to help us with this inquiry, which will be considering how the UK's exit from the EU will affect the current system in Parliament for scrutinising EU law and policy and what changes might be needed. This is our first evidence session. We'll be picking up on this in early September. Our aim is to understand the legacy and indeed any complications which might arise from that legacy that EU law will leave under the terms of the European Union Withdrawal Act 2018, and to consider how different Brexit outcomes might affect the status, reach and legal effect of EU laws and policies in the UK once it is outside the EU. I ought to add that, of course, while the European Union Withdrawal Act 2018 was going through, it was on certain assumptions which are liable to be radically changed in the event of a change of Prime Minister. And therefore, a lot of the questions might appear at this stage to be hypothetical, but we'll ask them nonetheless, particularly regarding the draft withdrawal agreement, because so long as we are where we are, we have to ask those questions. But by the time we got into September, the situation may have changed. Who knows? I do. An important theme running through our inquiry is whether distinctive systems and structures to enable Parliament to scrutinise EU laws and policies will still be needed after the UK leaves, and if so, how they might need to change to reflect the different status and effect of EU law and policy after Brexit. Of course, they use the expression EU law the whole time as if it will remain EU law as EU law, but that won't be the case, which actually raises the whole question of supremacy of Parliament and the extent to which in future there may be changes to the Withdrawal Act itself, because it's by no means clear or likely that it will remain exactly as it is, because that Act itself is capable of being changed by a future Act if indeed it was deemed necessary to do so. And I ask that question in the most general terms now, or put the question or put the point, because when the Withdrawal Act was going through, there was an assumption that the current government at that time, up to the 29th of June, which was the date of royal assent of that Act, was being conducted on a supposition which was then totally changed by what I regarded as an outrageous change on the 6th of July when we had Chequers and then into the draft withdrawal agreement. So there are lots of potential questions, not, I think, necessary for you to answer this afternoon, but I'm just putting that in context for the sake of the record, just in case anybody might think that there are those of us who assume that what was done in those days will necessarily apply in future. So we'll kick off this session with some questions on the status and effect of retained law under the EU Withdrawal Act 2018 before moving on to consider a range of possible Brexit outcomes. I'll do the first question relating to the following, the question is, what do you believe are the key features of the European Union Withdrawal Act 2018 regarding the status of EU in the UK after Brexit?
Do you want me to kick off?
Yeah. So it's the status of EU law in the UK after Brexit.
Well, first of all, can I say thank you for inviting us to give evidence. I should say I'm here as a member of UK and a Changing Europe, which is a non-partisan think tank, and so what I'm going to say will be based on my knowledge as a lawyer and not trying to argue the case for one side or the other. In respect of your question about the EU Withdrawal Act, as you know, it tries to deliver on three things. First of all, it repeals the European Communities Act, and so most importantly, it repeals both the notion of supremacy and direct effect, at least at first sight, and also turns off the mechanism by which EU law becomes part of domestic law.
On exit day.
On exit day.
Secondly, and you accept that exit day is the 31st of October as far as the law is concerned.
That's right.
And furthermore, that the European Council summit that took place on the 11th, 12th April clearly stated, in any event, 31st October, because that's what they said. But none of this has been ratified and the treaties haven't been signed. Can we just, as it were, clear that point?
Well, I agree with you entirely that the exit day at the moment is the 31st of October. It was a European Council decision which the UK...
Demand.
Well, I would call it... Legally, it was a decision. And I would... and the UK assented to that. And at the moment, that will be the day on which, under Article 50, we leave the European Union with or without a deal. And the only way that that date can be changed is if the UK were to request it and if the EU were to agree to it by unanimity.
But that relates to exit day, not to the question of repeal, because the repeal part of Section 1 of the Withdrawal Act is quite explicit. And as you slightly sort of elided that point when you said something, you qualified it and said as things stand or something like that, because actually the expression that the European Communities Act 1972 is repealed on exit day includes the entire
correct.
bag of all laws, treaties and European decisions and all the whole gamut in one place. But then you suggested that might not be absolutely as clear as it states. Well, I refer you to McCarthy's versus Smith.
The exit day is can be changed by secondary legislation, and that's why I said as it stands.
I beg your pardon.
And
yes.
so, but the fact is that exit day, the EU Withdrawal Act refers to exit day.
But the substance of the repeal of the 72 Act itself is law, but on exit day can be changed, but the rest of it can't. That's really the point, because it's an act of Parliament, it's express and it's clear, and therefore, despite some suggestions about challenging the issues in the court, which some people seem to be imagining could happen, it would be impossible for anybody to misconstrue the words of Section 1.
No, I think Section 1's extremely clear.
That's all I'm saying.
But so my caveat about turning off supremacy is that while the European Communities Act is indeed turned off under Section 1 of the 2018 Act, Section 5 of the EU Withdrawal Act actually nuances the position somewhat. And I can talk about that in a moment.
Well, that's what we're going to do. That's very clear. Thank you.
And so your question was, what are the aims and what does the Act do? So the first is to repeal the European Communities Act. Secondly, it's to convert, and to put it crudely, to convert the whole content of EU law into domestic law, so it becomes a new type of law called EU retained law. The notable exception to that continuity approach is in respect to the Charter of Fundamental Rights, which is not excluded. Which is expressly excluded. And then the third aim of the EU Withdrawal Act is to correct, to give these powers, the so-called Henry VIII powers, to correct aspects of domestic law which will not work in the event, particularly of a no-deal Brexit.
Now, can I just follow that up? Because I think the word deficiencies is what was used. Is that correct? Mm-hmm. Now, in that context, that's quite an elastic word. It can have a subjective or an objective interpretation. It wouldn't just be a mistyping or a mistake. It could be, because deficiency can mean something that is lacking. I mean, I haven't got the Oxford Dictionary in front of me. Perhaps Professor Pears has, or can think of an expression that betters mine. But I mean, the word deficiency is quite broad, is it not?
Yes, I mean, I wouldn't have used the word deficiency because it suggests...
Well, it wasn't my word, it was the word that was used at the time.
Oh, no, of course. Yeah. I wouldn't have used the word that the drafters of the Act used, because it could be understood as sort of suggesting a kind of criticism of the legislation that somehow needs fixing up because there's something wrong with it. I think that's misunderstanding. I think conversion or something like that would have been a better word. What we're actually doing with those powers in the Act is really altering the statute books to a different situation. which is the UK as a non-member state, and so all the references that assume the UK is a member state, which made perfect sense at the time, for those which don't make sense anymore, they of course have to be corrected in some way to refer to a UK agency instead of the Commission doing a review, or some different processes and so on that might be relevant. And of course, I looked at some of the secondary legislation which has been passed, and that to this end, and that of course is the sort of thing that it's been doing. It's also included things like transitional clauses on asylum requests and so on. So for me, that's the main purpose of the Act, as far as retained law is concerned, to keep it on the books, unless in some way we decide to alter it, either by means of that process or by means of another process. Of course, there are other acts or bills before Parliament which would make other changes related to EU membership. And of course, we've already had all that secondary legislation go through, which has made a lot of these changes already from the point of view of deficiencies. So I think that's the core of what we're looking at now. And as time goes by after Brexit, of course, there would be more substantive changes that are made to the EU law in the books, depending, of course, on what our relationship with the EU is.
But of course, there is a point at which there is a kind of connection between an existing EU law and then a modification of it, which may be made after we've left. So when that happens, surely you get into a rather curious situation, which is bit by bit, you move further away in time from the original proposal. You've also lost the purposive rule, because that doesn't apply as such once you've translated the whole of the treaties under the EU retained law concept into UK law, because that's going to raise quite an interesting question for the Supreme Court, which is to the extent to which you move back into the stare decisis method of interpretation as compared to purposive. Do you have any thoughts on that as a matter of interest?
Well, I think at some fairly early point we would probably have some important Supreme Court case law which answers these sorts of questions as to how much regard we still have for European Court case law, especially, and obviously there's two different categories, so you'd have to consider, I think, post-Brexit case law on the one hand, which isn't binding on the UK, and when would you make sense to take that into account or not, as well as there was pre-Brexit case law, which in principle is binding, but there are reasons where the Supreme Court can use to not follow that case law. So I think one of the obvious circumstances would be if there's a change in the EU legislation, you'd have to look carefully at it to see whether the prior case law of the Court of Justice was still relevant. Because a change to the legislation could be doing something quite different from what the prior legislation does, or it could be simply there to confirm what the Court of Justice has already said on that legislation, simply to write in some rule for the jurisprudence into the legislation. So in that sort of context, why shouldn't we still follow the prior case law? But I guess the argument is, well, isn't there something inherently different about being a non-member state which would require us to rethink our approach to Court of Justice case law anyway? And I think that is the key question the Supreme Court will have to decide yes or no. Regardless of whether there's been any changes to the legislation, that's a specific issue. But if there haven't been changes to the legislation, should we still rethink how we traditionally interpret it? Or should, of course, we just simply leave it to Parliament and the executive, whatever secondary legislative powers it has, to change the law if it wants to, if it really wants to do something differently from what the case law tells us to do. So I think that ultimately is what the Supreme Court will decide. I wouldn't sort of bet either way on which way it would necessarily decide it.
But that itself would be conditioned by the question as to whether or not a future Parliament might decide, on the principle that no Parliament can bind its successors, to decide to make changes to the Withdrawal Act in order to take account of the fact that the situation had moved forward, as you were suggesting, and that questions of judicial interpretation began to, as it were, get bogged down in the weeds of EU law, when actually Parliament decided that it wanted to be further unshackled in relation to these questions, and then decided later that it was going to modify the Withdrawal Act. And I've got sections 5 and 6 in particular in mind here, which gives supremacy to the courts in a manner which led to a very interesting exchange, and I was going to ask you whether you've had a look at the exchanges that we as a committee had with the Prime Minister, which, as I understood it, was not dealt with by DEXU at all, but was dealt exclusively in number 10 Downing Street. Are you familiar with that? It's quite a voluminous set of letters. Did you seem to, by nodding your head, suggest that you're aware of that?
Yeah, so I think the question that was raised was in respect of what would happen in respect of post-Brexit case law, and to what extent the British courts would be obliged to follow post-Brexit case law of the Court of Justice. And in fact, the language in the final version of the Act became more positive in the sense it was written in the positive sense, may have regard to, rather than a more negative, they can't accept. So what it's done is it's created a degree of flexibility for the courts. And I think in answer to your broader question about how the courts will react to all of this, is I think there will be a degree of pragmatism. They are keen to make sure that this system works in the post-Brexit world. There will be bumps along the way because there'll be things that nobody has thought of that will come up in the context of litigation. And I think with discussions I've had with various members of the judiciary, the determination is to make sure it works rather than being too overly technical about any particular point. So I think your original premise that the further we are in time away from Brexit or exit day, and particularly if there's been a conscious parliamentary intervention in a particular field, then the courts will obviously take that into account when trying to work out what the law actually means.
Yes. David Jones.
Just pursuing that, is it the case, as you understand it, that the British courts would retain a power of disapplication of even primary legislation in certain circumstances, even post-Brexit?
So this takes us to Section 5.2 of the EU Withdrawal Act, and this is the nuance that I referred to in respect of Sir William's question. So Section 5.1 says clearly the principle of supremacy of EU law does not apply to any enactment or rule of law passed or made on or after exit day. So supremacy is turned off in respect of post-Brexit legislation. But what's interesting is 5.2, the caveat in 5.2, and I'll read it for you, you may be familiar with it. It says the principle of supremacy of EU law continues to apply on or after exit day so far as relevant as to the interpretation, disapplication or quashing of any enactment or rule of law passed or made before exit day. And so essentially what that's having in mind is, take for example Article 157 of the Treaty on Equal Pay for Men and Women, which obviously is a treaty provision and obviously predates Brexit Day. Take also the Equality Act 2010, British legislation, which of course also predates Brexit Day. If there is an inconsistency between the Equality Act 2010, a provision in the Equality Act 2010, and Article 157, that inconsistency in the Equality Act will be disapplied. And so essentially supremacy carries on in respect of pre-Brexit enactments. But of course the major change is that if the British government of the day, the Parliament of the day, does not like what the courts have ruled, they will then be free to pass legislation to reverse the decision of the court that has found it.
Yes.
That's extremely important, and I'm very glad that you've made that point, because it's a sort of fundamentally goes back to my question about Parliament not being constrained in terms of a future piece of legislation it may wish to pass. The other thing I wanted just to touch on is the issue of retained law in the context of Article 4 of the now, what I would say, defunct, but notwithstanding draft withdrawal agreement. First of all, it was never signed. Secondly, it has never been ratified, either by us or by the EU. And it has a status of commentary in the media, which actually doesn't really quite match up, to, shall we say, to say the least, to its actual status as a matter of law. However, Article 4 that did contain the sort of mirror image of what we just discussed in terms of Section 5 and 6 of the Withdrawal Act. And I was rather tempted, I remember asking a question about this in an earlier session. Did they know that they were going to get Article 4 in the draft withdrawal agreement when they drafted 5 and 6? Because they put that into legislation, and then bingo, it suddenly appears under Article 4, where it talks about the requirement under Article 4 when we're being governed by 27 other member states, when we're not even there, where there is no Hansard, there is no record to speak of the voting arrangements, and at the same time we would be required to obey those laws in our own parliament, and indeed our citizens would be bound by those laws under Section 2 of the European Communities Act, as it were, despite the fact that it had been repealed. It seemed a very, very odd situation, and we haven't really been able to get into that because at this moment in time, the draft withdrawal agreement is regarded as defunct. But the principle is what I wanted you to address, which is this business of disapplication of law. Because for practical purposes, that's what Article 4 did under the draft withdrawal agreement in relation to laws that we wouldn't even be involved in providing for within the Council of Ministers, which is done behind closed doors. Do you have any comment on that?
Could I perhaps disaggregate some of the remarks that you have made? So the withdrawal agreement, and I agree with you entirely, it's not part of UK law because it is the implementing legislation, the so-called WAB, the Withdrawal Implementation Bill, hasn't gone through. But were the withdrawal agreement, or should I call it a withdrawal agreement, something along the lines of this sort of text, were a withdrawal agreement to go through, then we would go into a period of transition. And during the period of transition, which will either go to the end of 2020 or to the end of 2022, in that period of transition, you're absolutely right, we would be bound by new EU laws that are made over which we will have no say. That said, there won't be a huge proliferation of laws in that period because it takes now really quite a lot of time for new directives, new regulations to go through the European process.
But you know, with MiFID, for example, there was accelerated procedures. I mean, I think, if I may say, that is what I call a rather optimistic view, because where there are circumstances of urgency, it is well known that the EU does accelerate the procedures.
Yeah, I absolutely agree with you that in that period of transition we will be bound by laws, including laws which are adopted in that period over which we have had no say. And furthermore,
for the first time in our entire history, as far as I can judge, maybe since the time of King John.
So, and I would also say that the WAB, the implementation of the withdrawal agreement, will require essentially some of the things that have been turned off by the Withdrawal Act get turned back on temporarily during the transition period. And so sections 2.1 and 2.2 of the European Communities Act are likely to be turned back on, either cut and paste or will be temporarily reinstated during the period of transition.
As you know, I was repeatedly asking on the floor of the House for the best part of 3 months to see a copy of WAB, and we were never allowed to see it, and we still haven't. We understand there are varying numbers of pages, but it's a very substantial bill and included something of the order of 178 clauses, so I understand. I can't say because I haven't seen it.
No, and I haven't seen it either.
Well, that's encouraging.
But what I would say is that in order to give effect to the transition period envisaged by the withdrawal agreement, then bits of the European Communities Act would have to be turned back on, either turned back on in by reference to the European Communities Act or cut and paste and drafted in some very similar language.
But that transition period, which was specified initially, and you said up to 2020 and maybe 2022,
yeah.
actually, if you look, I think it's not Article 132 or is it 138, which actually specifies the extension of the transitional period, takes you into another potential extension of the transitional period, does it not?
Yep, so there can be, you're right, it's Article 132, and there can be a single extension.
A single, because originally in the first draft it had a blank, and nobody knew how long that was going to be, and then they said, okay,
That's
well,
right.
we'll put a date in. And what is the date in there that you've got in front of you?
I think it's the end of I think it's the end of 2022.
And that's a single act. There is a bit of interpretation over what that word means. Is it single in the sense it can only be done once?
That's how I read it, yes.
Yeah, I see.
And it's an extension of either 1 or 2 years, so it's either to the end of 2021 or the end of 2022.
Yeah.
Subject, of course, to both sides deciding in the joint committee, and issues about finance that would have to be discussed in, I'm sure, a very difficult environment as to exactly how the details of that and agricultural policy also work. On that point about new legislation, I think it's also worth pointing out that directors of the EU usually have a 2-year transposition period. So not much will be agreed in the near future, the next couple of months of the end of the Commission, but something agreed next year wouldn't apply until the middle of 2022 anyway. So most of what the EU would do over the next year or so would only be starting to affect us towards the end of any extended transition period, unless we're talking about something within the rather narrower scope of the backstop. A lot of what the EU might be doing over the next couple of years won't apply to us because of that delay in transposition.
Well, we have been into all this in quite a lot of detail, but I thought it was useful to sort of draw out some of these questions at this stage so that I can then get on to the other question which Mr. Richard Drax is going to ask.
Just before
Yes,
you
of course, by all
finish,
means.
you asked about Article 4 of the Withdrawal Agreement, and you rightly said that supremacy and direct effect would continue in respect of all EU legislation during the period of transition. But of course, at the end of the period of transition, the reference to direct effect and supremacy in Article 4 is only about the direct effect and supremacy of this withdrawal agreement text. And of course, in fact, this withdrawal agreement text, apart from in respect of citizens' rights, which potentially could carry on for a very long period, but this withdrawal agreement text will eventually become increasingly redundant because it will be replaced at some future date by a future trade agreement and its implementation in the UK. Essentially, this withdrawal agreement text is the divorce. And in the divorce, it's citizens' rights, which is, I accept, major, and this text will be important for EU citizens for decades to come. It's about money and how much we've got to pay. And of course, it's about the backstop. Now, the backstop has had a huge amount of attention, we know that. But if there is a future free trade agreement, that will replace the backstop, or indeed may prevent the backstop from ever coming into force. And so what's left of the withdrawal agreement is really quite small. And so although, yes, there is an express reference to direct effect and supremacy in Article 4, it's about direct effect and supremacy of the withdrawal agreement, which, while at the moment is important, in 20 or 30 years' time will really not be very important
Well,
at
that's
all.
quite a long way ahead if you consider what could be done in the meantime. And the other point I'd just like to finish on is this issue of the political declaration, because there are things embedded in that which have a degree of continuity about them. Would you like to comment on that?
Well, I think the
words, best endeavours, all that sort of thing.
I think the remarkable feature about the political declaration is it's a document that was written to please a large number of constituencies, and so it's rather unclear as to what direction of travel it will lead to. I think what we can probably say is it will be a far more intergovernmental style relationship rather than an EU style relationship. And I think that's what's rather interesting about the text of the withdrawal agreement in respect of what lawyers would term the remedies provisions, the dispute resolution provisions, which are much more of an intergovernmental style rather than an EU law style. And that may be a testing ground. They may have tested out some of the approach to dispute resolution in the withdrawal agreement in anticipation that it would be developed and built on in respect of any future free trade agreement.
And of course all this finally is against the background of two things that have come out in the last few weeks, one of which is continuous statements that the withdrawal agreement is dead, including what Stephen Barclay himself was saying as current Secretary of State. And the other, of course, is that the backstop is now being completely abandoned, so it would appear, from the statements made by two of the Conservative leadership contestants, on which I'm now not going to comment whatsoever. So, but just to put that into context, I think it's quite important. Richard.
Good afternoon to you both. What significance do you attach to Section 19 of the Act, which provides that the Act shall not prevent the UK from replicating in domestic law any EU law made on or after exit, or continuing to participate in EU agencies? Is it a simple statement of the obvious, or does it signal an intention to copy and paste future EU laws?
Well, it seems to me it leaves it open to government and parliament to decide how to go forward, which could be either unilateral or in an agreed treaty relationship of some form with the EU. So I can imagine either of those scenarios, depending on how the politics play out. Government might want to say, okay, we have a no-deal scenario, but we are willing in certain fields to continue legislative alignment in the interests of reducing friction to trade. If that's a policy, it might get adopted in legislation or secondary legislation. To some extent, of course, it stems from keeping retained law on the books anyway, as long as it's not changed, as long as it's updated to match EU development. So that would be a policy the government might choose to adopt or might not choose to adopt. And, of course, access to agencies does depend, on the other hand, on what the EU agrees to, because it's up to the EU to determine what the conditions are of access to agencies. And a lot of the EU's legislation on agencies does provide for non-EU participation. It's not unusual to have non-EU associates participating in the agency. So that is presumably what is imagined there, and it would obviously depend then on what both sides want to do in terms of doing that after exit day.
The only thing I would add to that is that any trade that's done with the EU, any trade in goods that's done with the EU, will have to comply with EU standards. And it's the same whether for Chinese goods that are being manufactured in China and they are being sold on the EU market. The question for the UK government will be, if the EU changes its legislation in respect of a widget, will the UK update our own legislation in line with the change made by the EU? Or will the UK say we will not do that and just allow the manufacturers to choose to comply with those standards if they want to sell into the EU? And this will be a fundamental question, and this actually will be a question, I think, for your committee going forward, and I think it's probably one of the rationale for your committee to carry on existing in some form. That,
are you encouraging that?
Well, I imagine it's important for us all to keep our jobs in some form, but...
For me, in the context of the EU, it's a matter of complete indifference, but I have to say that I understand what you're saying.
But if the government were to decide to go down that route, then clearly there would be a role for scrutiny. What is striking at the moment is that if we leave with no deal on the 31st of October, of course, as you rightly pointed out, the European Communities Act is turned off, including Section 2.2. And Section 2.2, as you know, is a sort of essentially speedy route for implementing directives and other EU measures without having by secondary legislation as opposed to by acts of Parliament. And it may be very inconvenient for the government where it wants to actually give effect to a piece of EU legislation, particularly in the short term, that they have lost the powers under Section 2.2. So there may have to be some legislation, even in the absence of the WAB, that reenacts something like Section 2.2.
Of course, there is a curious point about the argument on no deal. We're now talking about it in terms of law rather than either emotion or, for that matter, anything to do with the commercial aspects of it, which is that under Article 50, plus Section 1 of the Withdrawal Act, exit day is the 31st of October, and the provisions of Article 50 do terminate after 2 years unless there's an extension, so that it's not really right to talk about it as no deal, because actually the deal is that it terminates at the end of the prescribed period, which in this case will be the 31st of October. So for practical purposes, much of the noise and fury which turns on the question of no deal is actually based on a misunderstanding of what the EU law actually prescribes. Some people call it a default arrangement, but actually it's not even that. It's actually the law of the land, which is that on the 31st of October, the repeal of the European Community Act 1972 would come into effect.
That's true, but on the other hand, Article 50 does envisage some sort of divorce agreement, and if there is no divorce agreement, you're right, then the treaties cease to apply. Yeah. And the divorce agreement is of course, the text of that we've got in front of you, but which has not been ratified or turned into UK law by the WAB. But I think you actually make a very important point in respect of the future, and I agree with you that on 31st of October, Article 50 gets turned off. And actually, Article 50 is a relatively benign legal regime for negotiating relations with the EU. Post the 31st of October, in the absence of the or a withdrawal agreement plus transition, anything that's going to be done in respect to a future trade agreement would have to be done under Article 207, or Article on free trade agreements, or Article 217 on association agreements, read in conjunction with 218. I can see this is not very attractive to anyone who's not a lawyer, who finds these things very exciting. But the point is that the EU has made clear that it will not negotiate any free trade agreement until we have sorted out the three big ticket items which are currently contained in the withdrawal agreement. And
but
this will be a problem.
At that point get into what could be described as a very direct political situation, and that the mechanics after 3 years of what appears to be abortive negotiations now moves into a new phase on the 31st of October, so that as a matter of law, rather than of what people would like, we move into a completely different zone, and then it's more or less a question of political will and also the trade-offs between the two parties, the EU on the one hand, under a new European Commission from the 1st of November, and the United Kingdom under a new disposition, if I can use that expression, which appears likely on the face of it.
Except
you can absolutely jump in
when there's an opportunity. Sorry. I just had a question very specifically related to that point
Richard,
of 217 and 218. Sorry.
I always love hearing what Stephen has to say on these subjects.
217, 218 and how they would relate to the withdrawal agreement. So if we envisage a situation where we leave the European Union without a deal on the 31st of October, the legal basis for the relationship then goes to Article 207, 217 or 218. But the EU has made clear that the withdrawal agreement items have to be resolved before you can begin a negotiation on the new legal basis. Does that leave us in a kind of lacuna then? Because 207, 17 and 18 are not designed to deal with the kind of things that were negotiated under 50. If you envisage a position where the British Prime Minister then, let's say we leave without a deal, and for whatever reason the view is that we do need to try and get a better trade deal with the EU. The EU says, well, sorry, you have to resolve the issues that are under Article 50. What would be the legal basis then? Is there a way of copying and pasting the withdrawal agreement into a 217 or 218 legal basis? Is that possible? It's clearly unprecedented to mix those, mixing oil and water really. But it'd be very interesting to know what would happen if we were left in that legal vacuum.
Well, what we do know is that association agreements have to be agreed unanimously on the EU side. And usually they're mixed agreements, meaning that member states have to ratify them as well, although sometimes the EU either carves a bit out as an interim agreement or agrees to things treaties coming into force provisionally. So that's another possibility to speed things up a little bit on the EU side. Now, if you try to simply copy the whole text of the withdrawal agreement, I think it would be bound, whatever form it takes legally, on the EU side, it would have to be a mixed agreement because it involves, even if it's just for a transition period, the free movement of people. And the Treaty Article 79 of the TFEU says that the numbers of non-EU citizens admitted to employment markets of member states is a national competence. So we already know that alone makes it a national competence. So would the continuation of the aviation relationship, for instance. That's also a mixed competence, we know from the case law, probably several other things. But that alone, if we keep those things in place, makes it a mixed competence. Now, if you start taking things out, if you start taking out free movement of people, if you have a separate aviation treaty as the EU legislation on no deal in aviation says there should be, then it might be a little bit simpler. Of course, I expect we wouldn't be talking about exactly the same text of the withdrawal agreement. There would be some negotiation on some aspects of it that would be changed, might end up in separate treaties or not. But I think the simplest way forward is to call it an association agreement because of the fairly close relationship that's in it. And then, of course, the EU is also freer from the constraints which it perceives to have about Article 50 about negotiating a long-term relationship. Because, of course, the EU has always felt that it can't negotiate a long-term relationship under Article 50, even though, of course, the backstop in principle is unlimited. The text of the withdrawal agreement says, but in principle it's temporary, because of this perception you can't have a long-term relationship under Article 50. But, of course, you can as an association agreement. And so some of the concerns that some of the opposition parties have, for instance, about, well, it isn't a long-term relationship in terms of labour or environmental protection. We want to get a long-term relationship on that. Well, you'd be able to do that post-Brexit Day under an association agreement because you wouldn't have some kind of inherent time limit on the association agreement. So that would definitely change the possible dynamics of negotiations as well.
But on the question of association agreements, I have in mind the Ukraine agreement and the Moldovan agreement. There are elements in those which are effectively putting those particular entities, countries, into a very subservient position vis-à-vis the EU. So I just thought you might like to comment on the fact that there is quite a lot of commentary from distinguished lawyers on that question of Moldova and also Ukraine. And it's not just a question, it sounds so comfortable and harmonious to talk about an association agreement, but it's not quite as simple as that, is it?
But there are historically a wide range of association agreements. There's the treaty talks very briefly about having a close association.
There's Turkey, for example.
And so, Turkey, yes, has a degree of harmonisation. So do those countries that you mentioned. But if you look at Switzerland, the group of the 1999 treaties was officially on the EU side an association agreement, although it's only
well, they're having a stinking row with the EU right now, aren't they?
Yes, they are having a row, but other countries have rows with the EU as well. But if you look at countries in the Mediterranean, some of them have association agreements which are much less far-reaching with the EU, which don't go anywhere near as far as what Ukraine and Moldova had. Now, association agreements with Chile and I think with Mexico, they're both association agreements. I think with the Caribbean countries. And I think with Mercosur, what's just agreed, the trade part will be part of an association agreement as well. So you can have an association agreement without anywhere near as much legislative harmonisation as Ukraine or indeed the Swiss and Norway and Iceland have agreed to over the years.
I'm very grateful for that comment, but I know Philippa wants to come in. I think we could spend the whole afternoon on the question of association agreements, but I'm very grateful for your response to that. Philippa.
It was really just, once the Article 50 process is finished, is it not just picking up on your point, you then require national ratification and you actually need 27 countries and possibly some regional parliaments to agree, and that's where we then suddenly, it could take an awful lot longer because you're not negotiating with one negotiating partner.
That's why the Article 50 legal regime is more benign in that you only require a super qualified majority of the states. In fact, they have been operating unanimously, but you only require a super qualified majority, and you don't need national ratifications in respect of the text of the withdrawal agreement.
I think with respect, I'm just going to bring in David Jones, but I want to ask one last question on this, and it relates to the manner in which Article 50 was actually implemented. you may or may not remember from a report that we gave, I think it was in a year last March, as long ago as that, we were severely critical of the extent to which the government had effectively acquiesced in the guidelines in terms of reference which are prescribed by the EU, and therefore from the very outset the whole of the Article 50 process, which led to the difficulties in the withdrawal agreement, was that it became very much a one-sided operation, and we were supplicating the EU. I think those are the sort of words we used in our report. And it just seems to me that you use the word benign, but unfortunately it was anything but benign, because it was being driven by a desire to appease them effectively, to give them the means of implementing their terms of reference, their guidelines. So we effectively ended up by tying one hand behind our backs. And I don't know that I would regard that as benign in those circumstances, but that's my interpretation of it.
I only use benign in comparison to what's coming under 207 and 217. I wasn't describing Article 50 and its content as...
Now, I've had some very interesting interventions, but to have... that was a wonderful piece of music. It was very loud.
I just said that my adjective benign was in comparison to the legal regime under 207 and 217, which will be infinitely more complicated. But in respect of your point about sequencing, yes, the fact is that we triggered Article 50 without having a very clear idea of exactly what we wanted, both in the short and in the longer term. And, of course, once we triggered Article 50, the clock started ticking down. And the very fact that the EU got its way over sequencing meant that we were already, as you say, negotiating with one arm tied behind our backs, because the fact is that they insisted on sorting out the money, for example, without having any firm commitment as to what our future trade relationship might look like.
And were you astonished, and this is my last point before I move on to David Jones, were you astonished that we enacted the Withdrawal Act on the 29th of June last year, and it's only that 1 year ago, with royal assent on the 29th of June, on the 6th of July, without reference to the Cabinet, you then have a completely new arrangement which is thrust on them by virtue of the Chequers deal, which some people suggest was actually done in cahoots with the German Chancellor, and that effectively, within a matter of days, you then have an 80-page white paper, which I did point out at the time, was pretty extraordinary and I thought disastrous, which quite clearly had been planned without reference to the Cabinet over a period of time which must go back the best part of 9 months if you're going to take any kind of assessment of the length of time it does to produce an 80-page white paper, which led straight into what you said earlier, which was the manner in which the European Community Act 1972 was effectively turned inside out. And I put it to her on the 9th of July, how can you reconcile Chequers with the repeal of the 1972 Act? I mean, you made the point yourself earlier. It's an extraordinary state of affairs, is it not?
I think it's very unfortunate that discussions such as those that were held at Chequers were not held prior to the triggering of Article 50, so that there was a clearer idea of the direction of travel and what we could legitimately ask for. And while the Article 50 is primarily about the divorce, it does say that account will be taken of the future relationship, and I'm not sure that we pushed hard enough to say that actually we should be doing much more on the future relationship.
But there's no doubt that the Cabinet was deceived, and the same applies to Parliament in that context, if one was to assume that the arrangements which were apparent in the White Paper so radically changed the nature of the Withdrawal Act, which we've been discussing so far in this session, because Section 1 speaks for itself, and then you get a new arrangement under Chequers, followed by the Withdrawal Agreement, which actually has an incredibly invasive effect on Sections 1 and Sections 2 of the European Community Act 1972.
I don't
or at least on the repeal of those sections.
I don't want to comment on, I'm a lawyer, I don't want to comment on the politics of whether Cabinet was deceived or not, but what I would say is that the Chequers text could be read in different ways about the precise legal manifestation of that future relationship, and it could be more intergovernmental or more supranational depending on what the various mechanisms were put in place for monitoring that agreement.
But at any rate, it could be argued. David Jones, please.
Yes, you've clearly already correctly concluded that the object of this inquiry is to ascertain whether or not there's a need for the work of this committee to continue post-Brexit. And you've already mentioned that during any transition period, if in fact the withdrawal agreement is implemented, the UK will be subject to legislation that is developed in the European Union without any role in formulating that legislation. So do you think that there will be a continuing need for Parliament to continue to scrutinise new EU law and EU policies during a post-exit transitional period?
Well, if there's something like the withdrawal agreement, if there's any sort of agreement or even unilateral act to have substantial legislative alignment with the European Union, I think it would make sense to have some form of specialised process like this one. It might take a different form, maybe a subcommittee of something else, but it would make sense to keep something like this going in that scenario. Now, if we don't have either a treaty commitment or a unilateral commitment on legislative alignment with the European Union, then I guess there doesn't seem to be a particularly strong need for it.
I'm contemplating a post-Brexit transitional period,
right,
pursuant to a withdrawal agreement.
Okay.
In that context, do you think that there would be a role for scrutiny? And in fact, what would be the consequence of such scrutiny in practical terms?
Well, obviously there'd be the change that you don't have a scrutiny reserve because the UK is not being represented in the Council and so on. I suppose there would be the UK permanent representation would then, as a non-EU state, be making the sort of representations that the United States or India or Canada make about proposed legislation that they hear about, not being subject to the same flow of information, of course, as a member state, but they'll still hear about things that are published and officially, and we'll be making representations as to well, let's not do that, let's not do this is a bad idea, not having the power of the vote behind them, or MEPs there who are likely to agree with them, some of them at least, behind them, but nevertheless having that possibility. And I'm sure the United States has had some success and others have had some success in persuading the EU at different levels to reconsider legislation, and that would be the sort of thing we'd be aiming to do. So it's obviously a different relationship, you have to reconceive it, but it would be something that it would make sense to at least attempt to do, because you'd be wanting, I think, as Parliament scrutinising the executive, to know what position the UK government is taking. Should they be intervening on this proposal here, that proposal there, on artificial intelligence, as the new Commission President wants to propose? How much does that affect our industry in Cambridge and other parts of the country? Do we want to object to that? Do we want to suggest something else? That would be the sort of scrutiny you'd want to take of the executive. What are you saying to the EU? They might be more reluctant, of course, in a different environment post-membership to tell you what they're saying. But nevertheless, I think definitely that there's a strong place for scrutiny as long as a transition period under the withdrawal agreement applied.
Well, it's quite clear that government will have an interest in legislative developments in the EU, but equally, of course, the government has an interest in similar developments in the United States, which, of course, is a major industrial power, and what it does has an effect, directly or indirectly, upon this country as it does in other countries around the world. I mean, should we perhaps be extending the remit of this committee to scrutinising US legislation or Chinese legislation or Japanese legislation?
Well, I think that does make sense as well. The only thing is that there would be a distinct legal position if we're aiming at some major legislative alignment with the EU, whereas we're not, of course, aiming at that with the United States or India or anyone else. Now, if we no longer have any kind of legislative alignment with the EU, other than maybe some small issue here or there, then it would make sense to treat it exactly the same as everybody else. But if we're going to have an obligation of some kind of legislative alignment, then it does make sense to have at least more energy devoted to the issue. While I agree that it makes sense to have some energy devoted to what the United States does and India, there's always going to be a need for more energy related to what the EU is doing, as long as we have a legislative alignment commitment, if we do.
If we were to scrutinise EU legislation in such a transitional period, what would be the effect of that transition? What would be the weight of any reports that this committee delivered?
Well, I mean, you would be aiming, I imagine, to try and influence what representations the UK government was making, and you might be perhaps aiming to bring things to their attention that they hadn't placed enough pressure on, or from the committee's point of view, or perhaps you'd be aiming to urge them to take a different position. Don't criticise that new environmental bill. The majority of the committee is happy with it, or don't go along with that new environmental bill. The majority of the committee is unhappy with it. That is the sort of thing I imagine that the committee would be interested in, and also I imagine it would be interested in pointing things out from the perspective of future relationship negotiations and how it would feed into that. It would be going on at the same time. And I see a lot of your recent reports have talked about the post-Brexit implications of things that you're looking at. So we, in a sense, as the committee, would also, I imagine, be very interested in saying, well, look, I mean, if this is what the EU is doing in terms of asylum seekers' responsibility, how does that kick into an agreement we might want to sign with them or negotiate with them already on asylum seekers' responsibility, or the European arrest warrant, and so on. That might be something to flag up.
This is, at the moment, a powerful committee. We have scrutiny reserves, which we can decide whether or not to release. Post-Brexit, in that transitional period, we would not be a powerful committee, would we? We would be a fairly weak committee. We would just be seeking to exert influence rather than any sort of power that the committee has.
Well, yes, I imagine so. I mean, that's just simply the consequence of not being a member of the European Union. You're going to have less influence over what it does. But, of course, I'm sure, as I say, that the UK government in any scenario is going to be seeking to persuade the EU to do certain things or not do certain things, and that's much more important for us if we have some obligations of legislative alignment with the European Union. Then it's particularly important, and if it feeds back into future relationship negotiations, then that's particularly important too. So I think that's while the committee would have no longer such powers, it would still hope to, I imagine, try and be influential, as the International Trade Committee, other committees concerned with external relations, hope to have that kind of influence as well.
Would you like to add anything, Professor Barnard?
I think I would just say that Norway has a very effective embassy operation, but it does mean the staff there spend an awful lot of time having coffee and having meals, and I don't say this entirely in jest, because this is how they get information, and this is how they try and apply some degree of pressure or influence. The second thing I would say is that...
So, just before we leave that point, does the Norwegian Parliament have a committee that undertakes roles similar to this committee?
I'm afraid I don't know the answer to that question, but I think it does. I think it does as well.
New legislation has to be approved by the Norwegian Parliament under the terms of the EEA agreement.
So, of course, they are already much more proximate than we will be if we have some sort of CETA type of relationship with the EU. That was
but they, of course, are EEA members, aren't they? So there is a formal
Norway's
relationship
EEA
between... Right, okay.
But what they don't have is they don't have any voting rights, so they don't have any influence, formal influence over the shape of legislation. My second point is that, from my experience, the reports produced by parliamentary committees are taken very seriously in Brussels, because a lot of work's gone into them. They tend to be well written and they've consulted quite widely. And officials want to produce good quality legislation. They might not agree with the approach taken by the UK, because of course we won't be member states anymore. But if there are some technical points that we're raising that they hadn't thought of, it may well be that we still have some influence there.
Thank you.
So, Philippa Whitford, the next question, please.
Thanks, Chair. So moving to after any transition period that would come from a withdrawal agreement, obviously there's been a lot of focus on Northern Ireland. So how extensive a role does EU law play in underpinning North-South cooperation on the island of Ireland, avoiding a hard border and protecting the Good Friday Agreement? Those kind of three areas.
Well, I mean, it has been a mapping exercise, I think, the results of which were recently released, and the backstop in the withdrawal agreement refers to that. But despite that lengthy list of issues somehow linked to EU membership, I think the core is what the withdrawal agreement requires there to be in terms of continuing alignment, and that's mostly a long list of legislation relating to the free movement of goods. So that's where I think there would be a continued important role for scrutiny, assuming that the backstop came into effect, that whether it's the right place to have the scrutiny is maybe another question, because if we're only talking about texts that have to apply to Northern Ireland, it might be the Northern Ireland Committee or indeed the Northern Ireland Assembly or Executive, if they're working, that would be a better place to look at these things, or both. But that, I think, is more important in legal terms than this sort of broader cooperation, which of course is going to go on anyway, and it's significant and important between the UK and Ireland. But in terms of the specifics of the UK-EU relationship, it's not everything in the North-South cooperation that has a legal importance.
But obviously it was the UK that then proposed to change it from a Northern Ireland bubble, which was the proposal in December 17, to the entire UK bubble, even though Northern Ireland will have closer regulatory alignment. So avoiding that kind of divergence, does that not then create a pressure that the UK, via Northern Ireland, actually has to look at alignment with everything that the EU decides? That would relate to goods or agriculture or...
That would relate to the text of the backstop. Yes, I think that does make sense. If the UK government is going to go down the lines of what you could, I suppose, say as being aligned with Northern Ireland, therefore it's indirectly aligned with the EU in those areas, therefore it does make sense for a broader scrutiny to take place. I was thinking of a scenario where it's only Northern Ireland which is subject to these new developments in practice, but of course if that's not the case, it makes sense to have something broader. And if we're sticking with the UK-wide version of the backstop, if that were to come into force, of course there are things in there, as you say, which are UK-wide to start with, so therefore it does make sense to have a broader scrutiny of those things too.
Is it not the case that if the focus had remained on a Northern Ireland only backstop, and obviously around animal transfer, sanitary, phytosanitary, etc., it is all Ireland regulations already, that therefore we wouldn't have spent the last year and a half going round the same track? And your comment about being a bit further down the future relationship, we might actually have got more other things ironed out, whereas actually we've just been going round the same plug hole for a year and a half.
We don't have access to sort of parallel universe where that might have happened, but there's all sorts of interesting parallel universes you can imagine if we hadn't had an early election and so on, where would we be? But yes, I think that's possible, certainly, that things would have turned out differently if we hadn't gone down that route, but they might have still been a great difficulty of getting the numbers to pass the withdrawal agreement, because the DUP and some others I'm sure would have been still concerned about that. Perhaps you'd have insufficient numbers to pass anyway.
Are there other aspects around it that you think have not been considered here that would have been a solution to it? Obviously people have talked about alternative arrangements which are not yet in place, but people who really believed in alternative arrangements then in a way shouldn't be afraid of the backstop, because the alternative arrangements would come to the fore perhaps before it was ever required.
Well, I think some of those people would probably answer, I mean, I guess I shouldn't really speak for them, but I think they would probably answer that they don't believe the EU would act in good faith, that the EU would trap us into the backstop, even if the alternative arrangements objectively existed. That would be what they would argue, and that the EU has the capacity to do that. Of course, this argument about being trapped in a way works the other way around as well, because the backstop also guarantees access for the UK to EU markets for goods, and so we wouldn't be faced with a cliff edge as far as a potential no deal on goods exports, because that would be built in, not every detail, but at least some essential elements of our market access for goods to the European Union for the UK as a whole would be built into the backstop, and they couldn't unilaterally terminate it any more than we could. So there is that fact as well, which rarely gets discussed, but I think, to be fair, that is the concern that people have who advocate alternative arrangements.
Though actually, obviously, there is a lot of concern from the European side that the UK is being given a huge advantage as a non-member, and therefore they don't particularly want it to continue any longer than necessary.
Although I would say that, of course, the EU has a trade surplus with the UK in respect of goods. The EU is also worried about the backstop too, because for all the talk about no cherry picking, in fact there is cherry picking in respect of goods, particularly in respect to the island of Ireland. On the other hand, it is an agreement which is asymmetrical because it is about goods, it's not about services, and of course services as well, we have a trade surplus. So you can see that whichever side of the argument you're on, there is an argument that the backstop is not a good thing, but necessary in order to have got the agreement over the line as far as the EU was concerned.
And how important do you think EU law, and indeed the EU itself, both was and is to the Good Friday Agreement, the North-South relationship?
I think it's been absolutely essential. I think what's really been absolutely striking was that relations began to thaw a bit between Ireland and the United Kingdom through meetings in the Council. And so from that point of view, it's the operation of the Four Freedoms has facilitated an interchange without going down the highly politically significant route of saying we're abolishing the border on the map, but actually it has delivered that and a much smoother operation of smoother movement between the north and south of Ireland. And I think from that point of view, I think Section 10 of the EU Withdrawal Act is quite important. As you know, it says, I paraphrase, but nothing in various sections of this Act authorise regulations which diminish any form of north-south cooperation provided for by the Belfast Agreement, or create or facilitate border arrangements between Northern Ireland and the Republic after exit day which feature physical infrastructure. And so even if we leave without any form of deal on the 31st of October, there is this provision in the EU Withdrawal Act.
Though, I mean, and I think obviously the relationship between the likes of John Major and Albert Reynolds is overlooked in the whole process. And therefore, do you think that comes back to the need for ongoing scrutiny thereafter, in that obviously there will over time be divergence between Great Britain, perhaps the whole UK, and the EU?
And of course, that touches upon what our future relationship might be with not just the EU, but also with the US, and the implications of any future trade deal with the US and what it means in terms of particular standards for agriculture and agri-food. And of course, that's got issues for Northern Ireland. And so I think that's why there is still absolutely a role for this committee to look not just at necessarily EU standards, but also what's coming out from other fora.
Thank you.
Of course, in relation to the Belfast Agreement, you're probably aware of the remarks made by David Trimble. I mean, you know, it's not just an assumption that the Good Friday Agreement is the be-all and end-all in this context, because others take a different view. I just want to put that on record, that's all. Okay, David Jones, please.
Yes. Could you tell us what are the mechanisms that are contemplated to ensure that the United Kingdom complies with its obligations under the Withdrawal Agreement after the transition period has elapsed?
Well, there's several different aspects to that. Of course, the bulk of the obligations of the UK would have lapsed. And of course, there are reciprocal obligations, the EU's obligations to the UK would have lapsed, but that we still would be left with citizens' rights. We still would be left with some residual portion of the financial settlement. Most of it would have been paid, but some residual small portion of it left for a while. There would still probably be a few things like pending state aid cases which had begun before the end of transition, a few things like that, and there would potentially at least be the backstop for at least some period afterwards, a few other pending cases before the EU court, that sort of thing. And so there are different provisions on each of those, but the citizens' rights provisions have a specific rule about continued jurisdiction of the EU courts in relation to national courts of the UK for another 8 years. And then there's a specific provisions on Northern Ireland as well. But in general, for the withdrawal agreement, you'd be looking at the main dispute settlement provisions of the agreement, which would kick in at the end of the transition period instead of the ordinary jurisdiction of the Court of Justice, which applies throughout it. Then you have the withdrawal agreement dispute settlement instead, which has a decidedly intergovernmental flavour, but you might say a sort of European Union core, because if there's a dispute over EU law, and I think a lot of disputes would be about EU law, then you could end up with the Court of Justice ruling on it because of the EU side's concern about the autonomy of the EU law not having an international court rule on it, as far as binding the EU is concerned. So that is basically how it would work, yes.
Pausing there, so the court of one party to the agreement would have jurisdiction over the other party to the agreement?
Well, it would have jurisdiction to settle disputes, which would, as to the interpretation of EU law, which would then be binding on both sides, yes. But from the EU side point of view, you could look at case law going back nearly 30 years. That is actually unavoidable from their side's point of view. They would probably rather
from
that
their
way.
point of view, but I mean, so far as the UK is concerned, it's an unusual and novel state of affairs that we should be subject to the jurisdiction of the other party to an agreement to which we've contracted.
Yes, it is odd, but that is the, I guess you could say, hard to avoid outcome of having been a member for 45 years, that it's hard to extract ourselves immediately and fully. You've got a transition period, and then you've got some residual issues after that. But as I say, most of the obligations would have ended by then.
I'm sorry, I don't wish to appear rude, but why could this not have been passed to independent arbitration rather than to the jurisdiction of the European Court of Justice?
Well, I think in principle it should have been passed to independent arbitration, but as a matter of EU law, the case law of the Court of Justice prevents it being passed to independent arbitration, because according to the Court of Justice going back to 1991-92, a series of cases, you cannot have an international court ruling on the interpretation of EU law for the European Union. It has to be the Court of Justice which gives the final ruling on the interpretation of EU law for the European Union. Now, they've said you can have a different international court interpreting other law for the European Union. They're happy with investment dispute settlement with Canada to be subject not to the Court of Justice. As long as it's kept away from the Court of Justice, in fact, they're happy with that. But they're not happy with the idea that you could have an international body telling the EU how to interpret its own law. That's, from the Court of Justice's point of view, unacceptable.
Yes. Do you know of any international precedents for the court of one party to be the ultimate arbiter of a dispute with another party to a treaty or a similar arrangement?
Well, I don't know. There are many international treaties in the world, and I don't know offhand which might have a provision like that. I mean, most international treaties don't have much to do with courts anyway. They have informal dispute settlements and arbitrators and so on. Sorry.
I'm just going to say the Ukraine association agreement, I think what's in the withdrawal agreement's rather modelled on that. So
yes.
In answer to your question...
But of course the difference is that the Ukraine is seeking accession to the European Union, whereas we're leaving the European Union.
No, I take you, but you asked the question whether there
yes.
was another agreement that we knew of which had this sort of arrangement. And
I actually came across one in the case of Montenegro, which has got an arrangement with China under the Belt and Road Initiative, whereby a Chinese court has jurisdiction over Montenegrins and could actually, in certain circumstances, seize their property or order the seizure of their property. But it's a fairly, I think it's right to say it's a fairly rare and unusual arrangement, isn't it, internationally?
Well, like I say, most international treaties don't provide for courts at all. They provide for arbitration or perhaps just informal discussions. So in that sense, it's bound to be rare. But the EU court has taken this position consistently and makes it perhaps difficult to negotiate some of these treaties that it wants to negotiate. It's complicated probably their relations with the Swiss over the years, for example, that this is the position that they feel obliged to take. But they do feel obliged to take it because the Court of Justice has gone there and sort of stuck there over the years in its interpretation.
I appreciate this political point, but that does actually make it a lot more difficult to persuade parliamentarians that this is a good idea.
Yeah, I mean, and that's, I think, going on in Switzerland as well, that in similar provisions in EU negotiations with them aren't thrilling people too much in Switzerland. But nevertheless, that is that results from the position the Court of Justice has taken. You could argue, people did at the time, if you go back to 1991, as I remember, that this was going too far. But nevertheless, that's the position the court took and has stuck to it.
Of course, if you take Van Gendon Loos and Costa and all that line of decisions that were pre our entry, the clear determination of the European Court was that it could override the constitutional law of any of the countries in the EU. If one was to translate your impressive, shall I say, adherence to the nostrums of the European Court of Justice in this context. Imagine, for example, the United States contemplating the idea that there should be a superior court over the Supreme Court of the United States in relation to matters in which it had an intrinsic interest by virtue of an agreement with other countries. I mean, it is so unthinkable. And I suppose one would say the same about China, and I could give a list of others, and everybody in the room could do likewise. So the idea, the very idea, that outside the EU we would in any shape or form be subject to the jurisdiction of the European Court, whatever they may want or think, or indeed for that matter the institutions may want or think, really goes back to the point that I think Professor Barnard and I understood one another on, which was that the manner in which the whole of this process is being conducted is based on an assumption that we are somehow or other in a relatively subservient position, which is completely unthinkable from a political point of view, and in historic terms is literally an absurdity. I mean, we are an enormously vibrant country with an enormous historical heritage that goes back hundreds of years. The EU is just a sort of parvenu in this context. And however large they may be, we have as much right, as we pointed out in our report a year last March, to insist that we have an equal status with the other 27 as we go out. They may be more numerous. It doesn't mean they're any more effective. Some people would argue they're not any dysfunctional, but they're imploding.
Well, I mean, this argument about imploding has been used for, well, actually decades, if not the last 3 years, and been proven wrong quite a number of times. A number of people who said in 2016 there'd be a series of dominoes falling and have been proven wrong since, of course, is quite a lot of people. But to answer that, the more general point, I wasn't actually suggesting adherence to the Court of Justice jurisdiction. I was simply describing what the Court has said over the years. I mean, I actually said it isn't necessarily something that I'd agreed with. People disagreed with it at the time. Certainly some of its judgments on the ECHR I thought were ridiculous, and patent court and so on. Some of this line of case law. I mean, that is the situation that they're in. It's inevitably a withdrawal agreement is going to include a lot in it about winding down EU law relationships of the previous member. And so therefore, inevitably, a lot of the disputes are going to be about how to interpret EU law. That is inevitably going to bring about the jurisdiction of the Court of Justice according to the case law of the court. And you could say the case law is misguided, and it's certainly politically difficult for any non-member state to accept. I can understand that. It would be constitutionally difficult for many countries to accept. That makes perfect sense to me. I can see all the legal arguments against it. Many of them, I think, are very strong legal arguments. But I'm just simply describing the situation that we're in as a result of the case law of the court.
Indeed. Philip, you want to ask a question?
One of the things that struck me when I read the Chequers Agreement was almost the sudden recognition of some of the bits of the EU that were quite good, and a list of agencies that the UK government would suddenly like to stay part of. Surely, if that was negotiated through a withdrawal agreement, although it's all in the future, the political declaration rather than the withdrawal agreement, that then means if you're wanting to stay part even of bits of the club, that you would have to obey the rules of the club, and you would have to obey the umpire or the chairman or the whatever of the club.
Well, there are non-member states which agree to relationships with the EU without the Court of Justice having direct jurisdiction. So, I mean, with the Schengen Association Agreement with Norway and Iceland or and Switzerland, there's an agreement to pay due account to the court's rulings, but not a jurisdiction for the court as such, or even for the EFTA court as such under that arrangement. Equally for the EEA, it's, again, an obligation to take some account of the EU court's jurisdiction, but they have an EFTA court which is separate that applies EU law, which is that part, which is extended to those states. So, and there are many other examples of that. We don't necessarily have to accept the Court of Justice's jurisdiction. But if you don't accept the Court of Justice's jurisdiction, how else do you settle disputes? You can't just hand it to an international court or arbitrator. You'd have to have sanctions or something like that instead. Now, maybe that's the role we should have gone down with the withdrawal agreement. And as I pointed out before, in fact, the UK's negotiators actually did take cut back a lot of what the EU wanted in terms of the role of the Court of Justice in the withdrawal agreement. But they could only cut it back so far. If you're going to have any judicial dispute settlement, it has to be that court as far as EU law and the EU is concerned. Maybe, as I say, purely political dispute settlement with sanctions.
Are you familiar? I'm sure you are, because I know very well how much you know about all this, but some of us are following it as well in a different context, from a different perspective. And I just invite you to remember the former European Court judge, I forget his name precisely, who put out a blog, or in fact I think he made a speech, it was his retirement speech, that was it, in which he said that the idea that the United Kingdom could subject itself, or would subject itself to European Court jurisdiction, given the practices of that court, as he has experienced them while he was a member of that court, were so heinous, in his opinion. He actually described the prospect for the United Kingdom as entering into a viper's nest. Those are the words he used. Now, that may be rather exaggerated language, but it does sort of demonstrate the fact that if you're going to have a situation of the kind that you properly described, and I'm not ascribing the views to you personally, I'm saying that that's what they think, but we've given in to that, which, to answer, if I may, Philippa's point vicariously, is a reason why people like myself are so determined that we actually do leave, and leave fully and completely, and are not left with a hangover under this now apparently defunct withdrawal agreement with jurisdiction of another court, because actually, in a nutshell, what we end up with is being told what to do. And there are ways of avoiding that in an arbitration system, whereby the jurisdiction is, for example, chaired by an independent arbitrator, and you could have the two sides arguing the case. I made this case in the House of Commons in a speech I made about a year ago. In other words, I'm not sure that we need to make the assumption that because they say it, therefore we do it. I mean, that's really my point, and I'm not asking a question, I'm making an assertion, but that won't be for the first time. So if we move on to the next point, which is David Jones on the no-deal exit.
Yes. If the United Kingdom were to leave the European Union without a negotiated agreement, to what extent do you think that EU legislation or policies might constrain the future direction of legislation and policy making in the United Kingdom?
Well, I mean, if we leave with no agreement at all, and also no plans for a future trade deal, then at first sight the answer is that it will constrain very little, because that's obviously one of the reasons why people voted to leave.
But in practical terms?
In practical terms, what we're already seeing is, in order to try to reassure, for example, UK citizens living in Spain or elsewhere, that there are already attempts, EU-coordinated attempts, to get states to come up with special arrangements, and That is already underway, and also in the UK we've already introduced a settled status scheme for EU nationals, which does draw to an extent on the provisions of EU law. And so there's going to be quite a lengthy legacy effect of EU law in our system. But it is absolutely clear that if we do not have any formal agreement in place either now or also no future trading agreement, we will have much greater flexibility, and we will be able to repeal aspects of EU law which have become EU retained law in UK parliamentary jargon, and we will be able to repeal those.
So, to deal with the after effect of 40-odd years membership of the European Union, to disengage from that process, we would be able to do it informally rather than through the formal structures of a withdrawal agreement that implies the jurisdiction, supreme jurisdiction of the European Court of Justice.
Yeah, we already see some of the signs of that taking place, as I say, particularly in respect of citizens' rights issues or citizens' issues. And also we're looking at replacing what EU law lays down, for example, in respect to the European arrest warrant, with international arrangements. Now, you're right that those international arrangements don't come with the jurisdiction of the Court of Justice, but if you were a purist, you would recognise that our hands are still somewhat tied by these international agreements, because we are not an island. I mean, we are, of course, geographically we're an island, but we're not an island in terms of the broader regulatory sphere. And even if the rules aren't coming from the EU, there are different fora. So, for example, in respect to financial regulation, they'll be coming from Basel or wherever. So there are other places where where norms come from, which are outside the jurisdiction of the UK.
And this is the case really for every country in the world.
Yes, it is.
So
apart from perhaps one or two. With
in other words, we would be operating on a similar basis to most other countries throughout the globe.
That's true, and so in WTO law constrains states as well. It's not, and there is, WTO law forms essentially a floor, a fairly minimal floor of trading rules, and most countries have additional agreements because very few countries trade on WTO terms in and of themselves. But in reality, the WTO law will constrain what we can do. We can't, for example, just decide to subsidise the agriculture sector, which will lose out in the face of tariffs imposed by the EU, because that would go against the WTO agreement on subsidies.
So is it fair to Tracy, what you're saying is that very probably to an extent we would be constrained for practical purposes by what is happening in the European Union, but it would be our decision to as to the extent to which we are constrained.
Yeah, and constrained by other international organisations as well,
That's
of which the WTO is a prime example. But of course the enforcement mechanisms are state to state rather than private to state. And this goes back to the point that Sir William made earlier about the fact that Van Genderloos empowered individuals to bring claims to enforce EU law, to ensure that EU law was complied with. Some people think that's a good thing, others have said that interferes with the sovereignty of a state, and therefore we should go back to much more of a intergovernmental relationship, which is both less effective for the individual, but also gives more power to the state.
Thank you.
I think that really brings us to the end of today's session. Thank you very much indeed.
Thank you.
And I just thought I might mention in the context of qualified majority voting, which we didn't really go into, in relation to the decision making by other member states, that there is a remarkable book, which I wonder whether you've read, by Sir Paul Lever. He was the former British ambassador to Germany, and it received a very considerable amount of attention. It's called Berlin Rules, and he goes into it in very considerable detail, very interesting analysis, and I just think perhaps we have to bear in mind what he said, which is that no decision that he was aware of was ever made by the European Commission or the Member States, which wasn't cleared by those Member States or the Commission with Germany before action was taken, which does rather create a legal-political question, because if the majority voting system is being driven by consensus behind closed doors and we're not even there, however much we may want to have good bilateral relationships with France, Germany or whatever, the reality is that the decisions within the EU are effectively taken by on the basis that I've described.